Senator John Kennedy leaned back slightly in his chair, twirling a pen between his fingers as the hearing room buzzed with low murmurs and the occasional clicking of cameras. Across from him, seated high on the witness platform beneath the imposing seal of the United States Senate, Judge Amy Coney Barrett adjusted the microphone in front of her with deliberate precision. Her expression was calm, collected, too calm. The tension wasn't spoken aloud, but it hung thick in the air like southern humidity before a summer storm. Everyone in the room sensed it. This wasn't going to be a routine exchange. Just 12 months earlier, during a similarly public hearing, Barrett had been caught off guard by a line of questioning from Kennedy that exposed an uncomfortable gap between her judicial rhetoric and her record. He had done it with that trademark mix of charm and deadly precision, wrapping a trap in a folksy idiom so subtly that she hadn't even seen it closing around her until the audience laughed and the headlines wrote themselves. She had smiled through it then, but she hadn't forgotten. And now she was back, not just to testify, but to even the score. The chairman gavelled the room into order, calling the Judiciary Committee hearing into session. The topic on paper was a proposed amendment to the Federal Jurisdiction Reform Act, dense, dry, and easily ignored by most Americans. But behind the legalese was a deeply political issue: the balance of power between federal courts and state legislatures. It was a battlefield disguised as a bill, and both sides knew the stakes. Barrett was the star witness, invited under the pretense of clarifying judicial interpretation, but her real reason for appearing, whispered among aides and hinted at in off-the-record briefings, was to confront the man who had humiliated her last time. She'd come prepared, not just with precedents and policy language, but with rhetorical traps of her own. In her briefcase lay a set of legal hypotheticals drawn straight from Kennedy's past legislation, crafted to trip him up, to make him contradict himself or stumble in front of the cameras. Kennedy, however, didn't seem the least bit fazed. Dressed in a rumpled gray suit, his tie slightly off-center, he looked more like someone's small-town uncle than a constitutional scholar. But behind the disarming accent and the self-deprecating wit was a man who had studied Blackstone for breakfast and argued statutes like chess. Barrett knew that now, which made this moment all the more dangerous. As her name was called, and she rose to deliver her opening remarks, Barrett allowed herself one brief glance at Kennedy. He met her eyes with a slow smile, not smug, but knowing. The kind of smile that said he saw the setup coming from a mile away. Still, she pressed on. Her voice was steady, her phrasing meticulous, but beneath her carefully crafted tone was a challenge, one Kennedy understood instantly. This wasn't a hearing, it was a duel, one built not on weapons or volume, but on logic, memory, and the ability to turn a sentence into a snare. And as the first question loomed just minutes away, every camera lens in the room turned slightly, waiting to see whether the old Louisiana fox had finally met his match, or was about to teach another lesson in legal survival. The hearing paused briefly for a procedural formality, but the real drama simmered beneath the silence. Viewers at home leaned in a little closer, drawn not just by the substance of the debate, but by the contrast it embodied. On one end of the table sat Judge Amy Coney Barrett, sharp as a scalpel, her words measured and deliberate, the very portrait of modern judicial authority. Appointed to the highest court in the land, her legal pedigree was undisputed. Notre Dame, federal clerkships, the Seventh Circuit, and now the Supreme Court itself. She carried herself like someone used to being the smartest person in every room and rarely challenged on it. Across from her sat Senator John Neely Kennedy, looking, to the untrained eye, like he might have wandered into the wrong building. His tie was still a little off, his accent thick with Louisiana drawl, and he had that habit of squinting at people like he was either trying to read their soul or decide if they were selling snake oil. To some, he came off like a caricature of a Southern uncle, quirky, long-winded, maybe a touch behind the times. But to those who knew better, that was just camouflage. Kennedy didn't advertise his background. He didn't need to. But the record spoke for itself. A magna cum laude graduate of Vanderbilt, a Juris Doctor from the University of Virginia School of Law, and a Bachelor of Civil Law from Oxford University, where he graduated with honors. Not exactly your typical backwards resume. He taught constitutional law at LSU for more than a decade, long before he ever won a Senate seat. And he'd spent years working in state government, crafting financial policy and navigating constitutional disputes that would make most lawmakers blink. He once said, half joking, that he learned more about government from feeding chickens on his uncle's farm than in any law school. But that didn't mean he hadn't read every page of the Federalist Papers twice. The trick was, he let you think he hadn't. Barrett, for all her poise, represented a kind of polish that many Americans no longer trusted. Too articulate, too clean, too certain. Kennedy, by contrast, stumbled just enough in his delivery to feel real. He spoke in metaphors, some folksy, some bizarre, that made his critics roll their eyes and his supporters nod with quiet pride. When he said something like, "You don't have to be Einstein to know a skunk when you smell one," it was both ridiculous and razor-sharp. The tension between them was more than personal, it was archetypal. Barrett stood for the institutional authority of the court, cloaked in tradition and guarded by precedent. Kennedy embodied the skeptical citizen, the voice of the forgotten states, suspicious of elite consensus and armed with inconvenient facts. But there was something else too. Despite her past embarrassment, Barrett didn't underestimate Kennedy, not anymore. She knew what he was capable of, and it showed in the way she chose her words, careful not to give him easy ground. She was playing defense with the confidence of a quarterback who'd memorized the playbook, but she'd seen what happened last time. One wrong step and Kennedy would walk her right into a rhetorical ditch with a smile. As the chairman recognized Senator Kennedy for his opening line of questioning, the room fell still. He leaned forward slowly, tapping the microphone to make sure it was on. Then he smiled, that half-lidded, half-amused grin that looked more like a man preparing to tell a fishing story than spar with a Supreme Court justice. "Judge Barrett," he drawled, "thank you for being here today. I know we've got some real serious law to talk about, so I hope you don't mind if I ask it in plain English. That's the only kind I speak." A few chuckles floated through the room. Barrett didn't smile. She nodded once, waiting. Somewhere between a Southern storyteller and a legal assassin, Kennedy was about to begin. And while millions watching assumed he was about to get outclassed, a smaller group, those who'd seen this play out before, sat up a little straighter. Because when John Kennedy started slow and polite, it usually meant he was setting the hook. The room seemed quieter than it had any right to be. The hum of electronics, the shuffle of staffers taking notes, the muted clicks of cameras, everything faded beneath the weight of expectation. Kennedy had just finished his opening pleasantries, and now it was Judge Barrett's turn to respond. She didn't waste time. "Senator," she began, voice smooth and deliberate, "in reviewing the draft text of the state court's autonomy provision, which you co-sponsored last year, I noted several constitutional ambiguities. Specifically, the language regarding judicial preemption appears to conflict with existing supremacy doctrine as established in Cooper v. Aaron." She didn't raise her voice. She didn't need to. The name of the case alone carried gravity. Kennedy nodded slowly, blinking twice, expression unreadable. A slight smile tugged at the corner of his mouth. "Well," he said, scratching the side of his neck, "I guess I ought to listen closely when a Supreme Court justice calls something I wrote ambiguous." Barrett didn't respond to the quip. She was already flipping pages in a thick binder in front of her, crisp white paper marked with blue tabs. "I'd like to focus on Section 4, she continued. "The clause states, and I quote, 'No federal ruling shall invalidate state court interpretations of state constitutional provisions, unless said interpretations exhibit gross deviation from established norms of jurisprudence.'" That's a pretty vague threshold, Senator. What precisely constitutes a gross deviation? Kennedy leaned back and pursed his lips. "Well now, that's a good question," he replied slowly, glancing down at his notes without really looking at them. "I reckon that'd be up to the courts to decide." Somewhere behind him, a Republican senator shifted in his seat. Across the aisle, a Democratic aide smirked. This was exactly what they'd expected, a legal trap disguised as an inquiry, and Kennedy was about to walk into it. Barrett pressed forward, no trace of condescension, but plenty of sharpness beneath the surface. "So we're left to judicial interpretation of a standard you admit is undefined," she said. "Is that consistent with your repeated statements favoring strict constructionism, or is this an exception?" Kennedy shrugged. "I like my laws like I like my gumbo, Judge. Thick enough to stick to the bones, but not so thick you can't stir it." A few soft chuckles again, but Barrett didn't flinch. She turned another page. "And yet the proposed statute grants state courts binding interpretive authority on constitutional questions that may impact federal law. That appears to contradict both the spirit and the letter of Marbury v. Madison. Were you intending to shift interpretive primacy away from the federal judiciary?" Kennedy paused, just for a beat. "Well," he said finally, "you've got a point there. I'd say we were trying to nudge things back toward what the framers might have called a more balanced vision. Some folks think Washington's been hogging the spotlight a little too much." Barrett raised an eyebrow, her tone sharpening slightly. "So to clarify, you're supporting a bill that introduces deliberate constitutional tension based on a loose reading of originalist intent. That seems like an odd position for someone who criticizes judicial activism." The room stilled again. This wasn't just a line of questioning, it was a scaffolding. She was building an argument with him inside it, hoping he wouldn't notice until the floor dropped out. Kennedy tapped his pen on the desk, once, then again. Slowly, a few seconds passed. He leaned in slightly toward the microphone. "Judge, I'm mighty glad you brought all this up," he said. "I was hoping we'd get a chance to talk about that language. You see, when we were drafting that section, there were 3 different versions floating around. The one you just quoted was actually a compromise version, and truth be told, I didn't love it." Barrett tilted her head just slightly, sensing the shift, but not yet clear on where he was going. "I pushed for tighter language," Kennedy continued. "Something closer to Justice O'Connor's old framework on federalism, flexible, but with a backbone. Unfortunately, politics is like cooking a casserole with too many chefs. You gotta let some folks sprinkle their own spices in, or the whole thing falls apart before it even hits the oven." Another chuckle, slightly louder this time, but Barrett stayed locked in. "So are you saying, for the record, that the bill's current language does not reflect your legal position?" Kennedy smiled gently. "I'm saying, for the record, that I never claimed the bill was perfect. I claimed it was necessary." Barrett leaned forward, not missing a beat. "And if its imperfection weakens judicial coherence at the national level, is that a price you're willing to pay for political expediency?" The air thickened. That was a surgical strike. Kennedy took a breath and tilted his head, as if considering how best to respond. "Let me ask you something, Judge," he said, tone still friendly but firmer now. "Do you reckon the Constitution's ever been perfectly coherent?" Barrett hesitated, briefly, not long enough to lose control, but enough to concede the weight of the question. "Coherence is an aspiration," she replied. Kennedy nodded slowly. "And politics, as you well know, is an exercise in applied imperfection." She didn't respond. He smiled again, not broadly, but like someone who had just spotted a familiar trail marker in deep woods. Behind him, another senator leaned forward. Someone whispered. Outside the room, tweets were already flying. Barrett looked down at her binder once more, lips pressed together. This was not how she expected the exchange to go. She had built a beautiful trap, but Kennedy had paused just long enough, stumbled just slightly enough, to slip through the bars before they shut. And now he was starting to circle her with questions of his own. It wasn't over yet. Not even close, but the first volley had landed, and the room knew it. Judge Barrett had fired the first shot, but the old Louisiana fox hadn't blinked. Kennedy adjusted his microphone with the ease of someone not in a rush. He flipped a page in his binder, though no one was quite sure if he was actually reading from it or just buying time in a way that looked endearing. Then he cleared his throat and leaned in, voice still mild, still soaked in Southern cadence. "Judge," he said slowly, "since we're talking about statutory language and what makes a term too vague for constitutional comfort, let me ask you a quick question, if I may." Barrett gave a cautious nod, unsure if this was a genuine query or a curveball wrapped in homespun manners. "You familiar with the term substantial burden as used in IFRA, the Religious Freedom Restoration Act?" She gave a slight smile. "Of course." "Well," he continued, "that phrase has been litigated more than a bar tab at closing time. But the Supreme Court upheld it, didn't they? Despite it being, what's the word, impressionistic." Barrett's smile faded just a hair. She knew where this was going. "And if memory serves," Kennedy added, flipping to another tab in his binder, "in Burwell v. Hobby Lobby, the court said that as long as an individual sincerely believes that the government's actions put a substantial burden on their religious practice, the burden exists, even if no third-party harm is shown." That was, 2014. He wasn't looking for confirmation, he already knew the answer. Barrett folded her hands. "That's an accurate summary." Kennedy nodded thoughtfully, tapping his pen twice against the desk. "So let's not pretend that federal statutes don't sometimes deal in fuzzy terms. Substantial burden, reasonable accommodation, heck, even undue hardship. All of them require courts to fill in the blanks. And somehow, we all still wake up the next morning with a flag over our heads." Barrett didn't respond. Her silence said more than words might have. Kennedy wasn't done. "Now let's take a look at another case," he said, lifting a different sheet, the corners dog-eared from use. "National Federation of Independent Business v. Sebelius, 2012. The big Obamacare case. You'll remember that one." No one in the room had forgotten it. "In that case," Kennedy continued, "the majority ruled that the individual mandate couldn't be justified under the Commerce Clause, but it could be upheld as a tax under Congress's taxing power. That was Chief Justice Roberts' written for the majority." Barrett didn't flinch, but her eyes narrowed slightly, watching him. "What folks forget is the dissent," Kennedy said. "Now I happen to think the dissent made a good deal of sense, especially when it said that allowing the federal government to penalize inactivity opens the door to, quote, compelling individuals to buy broccoli. Which brings me to your own opinion, Judge." He turned the page slowly, deliberately. "In a lecture at Notre Dame back in 2018, you referenced the dissent in Sebelius, and you called it, and I quote, a compelling cautionary tale about judicial overreach dressed as pragmatism. You said it blurred the lines between judicial interpretation and legislative authorship." He looked up, eyes locking with hers. "I agreed with you then, still do." Barrett blinked once. A ripple of tension passed through the room, not a word spoken, but every staffer, every reporter, every intern at the back of the gallery sensed it. Kennedy had just laid a trap of his own, and Barrett had stepped one foot into it. "What I'm getting at, Judge," Kennedy continued, his voice still smooth as a front porch breeze, "is that if we're going to raise alarms about ambiguous statutory terms, we ought to be consistent. You've defended laws with broad language when it fits the jurisprudential climate you prefer. But when a bill comes from the other side of the aisle, suddenly it's all vagueness and overreach." Barrett opened her mouth, but Kennedy raised a hand, not rudely, just enough to signal he wasn't finished. "Now, I'm not accusing you of bad faith. I respect your work. You're sharp as a tack and 10 times as fast. But I do think sometimes even the smartest folks can fall into the trap of their own principles." He paused, then looked at the committee chair and back to Barrett. "I believe in state sovereignty. I believe in federalism that ain't just decorative. And I believe we all ought to be a little more honest about how flexible we're willing to be, depending on which side of the law is doing the stretching." The room was still, dead still. Barrett didn't answer right away. For the first time that day, she looked as though she were choosing her next words very carefully, not because she was unsure of her argument, but because she was now aware she wasn't debating an amateur. She wasn't correcting a misinformed senator. She was engaging with someone who had just quoted her own words back to her and used them as a scalpel. Kennedy gave no indication he was gloating. He simply flipped his notes closed and folded his hands. The senators on either side of him exchanged glances. One of the younger aides in the gallery mouthed something inaudible, then typed furiously on a tablet. Barrett finally spoke, her tone a shade cooler than before. Senator, I appreciate your insight, and I agree that jurisprudence demands intellectual consistency. That said, context matters. Legislative drafting, judicial interpretation, and constitutional principles must all be read through the lens of their time and application. Kennedy nodded. Fair point, he said. But then I suppose that means we agree it's possible for a law to be vague and still constitutional, provided it's applied fairly. Barrett paused. Yes, she said finally, that's possible. It wasn't a concession, but it wasn't a rebuttal either. And that was when everyone in the room realized something had shifted. Kennedy hadn't just defended his bill, he'd reframed the debate. And Barrett, for all her preparation, had just found herself playing catch-up. Kennedy sat still for a moment longer, letting the silence do the work for him. He wasn't in a hurry. His voice had already shifted, less charm, more precision. He was done playing defense. Now it was his turn to ask the questions. Judge Barrett, he began, tone courteous but unmistakably sharpened. Since we're on the subject of vague legislative language, and since you've rightly pointed out the risks it poses to judicial clarity, I hope you'll indulge me in a hypothetical. Barrett gave a cautious nod. Of course. Kennedy leaned forward, folding his hands in front of the microphone. His next words were measured, almost too measured. Imagine a federal statute granting administrative agencies discretion to act in the public interest without defining that term. Now, would you say that's a sufficiently precise legal standard? Barrett answered with confidence. Standing alone, it would be considered broad, but it depends on context and historical application. The court has often deferred to agencies under Chevron and related doctrines when statutory ambiguity arises. Kennedy nodded along as if she were making his point for him. Right. So ambiguity is tolerable if it lives in the right neighborhood. She didn't respond to that one. Kennedy opened a folder and pulled out a single page. It wasn't thick like the binders on the table. Just one printed sheet with 2 highlighted lines. He held it up slightly, not for the cameras, but just enough to draw attention. This, he said slowly, is from the majority opinion in a case called Matlock v. United States. The court upheld a vague statutory term related to wiretap protocols on the grounds that, and I quote, statutory flexibility enables practical enforcement of constitutional protections. Barrett's eyes narrowed slightly. You remember that case, don't you, Judge? I do. You should, Kennedy said, a bit more pointedly now. You joined the majority. Barrett blinked once. Senator, that case involved national security exceptions, different context. Sure, Kennedy said, almost amiably, but the principle still holds. Vague language upheld because the court believed the underlying application justified it. He let that settle in before continuing. And if we're consistent, as we both say we ought to be, then you'd agree that vague language can be not only tolerable but necessary in complex legislative environments. Correct. Barrett hesitated, her response a beat slower than before. In certain cases, yes. Kennedy's eyes twinkled just slightly. He was winding the thread tighter now. Well, I appreciate that, Judge, I really do. Because I had a funny feeling when I read your critique of the state court's autonomy provision that maybe, just maybe, we weren't debating vagueness at all. Maybe we were debating who gets to be vague and when. Barrett straightened in her seat. That's a mischaracterization of my critique. Is it? Kennedy countered gently. Because when the court upholds agency discretion under broad terms like public interest or reasonable delay, the world keeps turning. But when a bill tries to give state courts a little breathing room under similar language, suddenly it's a constitutional emergency. Barrett opened her mouth, but Kennedy raised a finger, not to silence her, but to pivot. Forgive me, Judge. One more quick question before I yield the floor. She waited. If ambiguity is acceptable when it furthers federal goals, national security, regulatory enforcement, taxation, why is it suspect when it furthers state-level autonomy? Don't both derive legitimacy from the same constitution? Barrett's jaw tensed, just enough for trained eyes to catch. Because the federal government is bound by constitutional constraints that define its enumerated powers, she replied carefully. State autonomy, while protected, must operate within the supremacy of federal law. Kennedy nodded solemnly, as if her answer confirmed something for him. I agree, he said, which brings me to my final point. He reached for one more page, older than the rest, slightly yellowed at the edges. It looked like it had been printed from a scanned copy of an antique law book, the kind you didn't cite unless you were sure of your footing. This, he said, holding it up, is from Sir William Blackstone's Commentaries on the Laws of England, Volume 1, published 1765. The room held its breath. In it, Kennedy said, voice now carrying a different tone, low and precise, with the weight of someone quoting scripture, Blackstone writes, "It is better that laws be clothed in general terms than made too rigid, for over-precision leads to contradiction, and contradiction is the death of legal clarity." He looked straight at Barrett. Now I'm just a senator from Louisiana, but I figure if Blackstone warned us that overdefinition leads to contradiction, then maybe our job ain't to fear ambiguity, but to handle it responsibly. He paused, letting the silence stretch. And with all due respect, Judge, that principle cuts both ways. Whether the statute comes from Washington or Baton Rouge, clarity is a goal, not a guarantee. And fairness, he added, requires we judge ideas on their merit, not their mailing address. Barrett sat quietly, fingers interlocked in front of her. A flash from a camera went off. No one said anything. Kennedy leaned back slightly, the slightest breath of relief in his posture. He hadn't raised his voice. He hadn't made it personal. But in the space of 10 minutes, he'd taken a critique, unraveled it, reframed it, and turned it into a broader lesson, one Barrett hadn't anticipated being on the receiving end of. She exhaled softly. Senator, she said finally, your points are well taken. I'll reflect on them. It wasn't a concession, but it was the closest thing to one, and that was all Kennedy needed. He nodded respectfully, closed his folder, and sat back in his chair. Across the room, a Democratic staffer mouthed something under his breath and typed furiously. Outside, the clip was already being clipped. Kennedy hadn't just survived. He'd shifted the frame, moved the goalposts, and reminded everyone watching that sometimes the man with the southern drawl and the crooked tie wasn't just telling stories. Sometimes he was laying foundations. And today he'd laid one beneath the feet of a Supreme Court justice. It didn't take long. Within minutes of the hearing recess being called, the clip of Senator Kennedy quoting Blackstone was already making its way across the internet like a brushfire in a dry field. The official C-SPAN feed was still uploading, but phone recordings and screen captures had already gone viral. One Twitter user posted a 47-second snippet with the caption, "When the old man with the drawl flips the script on a Supreme Court justice, watch this." In under an hour, it had crossed 1 million views. The legal world took notice first. Professor Alan Greaves from Harvard Law School, not known for hyperbole and rarely one to comment on Senate proceedings, tweeted, "Today, John Kennedy gave the clearest public masterclass on statutory interpretation I've seen in 20 years of teaching. Substance over show, that's how you do it." Dozens of his colleagues across the country chimed in, quoting the tweet or adding their own analysis. Suddenly, the term Kennedy Doctrine began trending among legal circles online, a mixture of awe, amusement, and genuine intellectual admiration. Cable news wasn't far behind. MSNBC ran a breaking segment titled, "Louisiana Senator Leaves Supreme Court Justice Speechless." CNN dubbed it, "The Southern Legal Gambit No One Saw Coming." Even Fox News, often critical of elite judiciary figures, featured the clip under the banner, "Kennedy Teaches the Constitution Again." The captions ranged from tongue-in-cheek to celebratory, but the message was the same. Something unexpected had just happened, and it wasn't theater, it was substance. In the blogosphere, law students and young attorneys were dissecting the exchange in real time. One widely shared blog post came from a Notre Dame law graduate, a former student of Judge Barrett herself, who opened with, "I never thought I'd write this, but today I found myself nodding along with John Kennedy more than with my former professor. And I say that with deep respect for her." The post went on to detail the layered reasoning Kennedy had used. his calm dismantling of the vagueness argument, and his surgical citation of Barrett's own words against her. Even those who didn't normally align with Kennedy politically had to admit it wasn't about partisanship. It was about precision, and he had shown it in spades. In Louisiana, local news outlets replayed the clip on loop, adding folksy commentary about our Senator showing the big city lawyers how it's done. One anchor called it the intellectual equivalent of a crawfish boil, messy at first glance, but expertly handled by someone who knows what he's doing. But the reach wasn't confined to the South. By evening, legal TikTok creators had cut and remixed the footage into short educational breakdowns. One young public defender posted a stitched video that opened with her wide-eyed reaction, followed by, "Y'all. Senator Kennedy just ethered a Supreme Court justice with a Latin quote and didn't even break a sweat." On Reddit, a thread titled "Kennedy's Blackstone Moment" became the most upvoted post of the day on Our Politics. The top comment read, "This is what happens when you underestimate someone who speaks slowly but thinks fast." Even in circles that typically viewed Kennedy with skepticism, there was something unmistakably satisfying about watching someone dismantle a power dynamic not with anger or performance, but with facts. Facts wrapped in charm, layered with historical weight, and delivered with the timing of a veteran litigator hiding behind a country lawyer's smile. Meanwhile, in faculty lounges and law libraries, conversations were happening that hadn't occurred in years. Professors were revisiting Kennedy's analogies and referencing them in classroom discussions. The Blackstone quote in particular began to appear in academic tweets, citations, and early drafts of legal op-eds scheduled for weekend editions. One senior fellow at a constitutional law think tank posted, "It's been a while since I saw a sitting senator thread a needle like that, let alone do it by outciting a Supreme Court justice." Whatever your politics, you have to admire the craft. By late afternoon, John Kennedy was trending nationally, not for a scandal, not for a gaffe, but for legal reasoning. That alone felt rare. It wasn't about a partisan win. It wasn't a dunk or a takedown. It was a moment of clarity in a space too often clouded by noise. And amid all the buzz, Kennedy himself remained characteristically quiet. He hadn't posted a thing. No self-congratulatory tweet, no press release. He went back to his office, reportedly ate lunch with a small bowl of red beans and rice, and then resumed his usual schedule. When a reporter caught up with him in the hallway later that evening and asked what he thought about the reaction, Kennedy paused, looked at her with that same half-smile, and said, "Well, darling, I just asked a few questions. Folks can decide the rest." But everyone already had. Across party lines, across law schools and legal communities, the consensus was clear. John Kennedy hadn't just held his ground, he'd reshaped it. And somewhere in that subtle shift, a new kind of respect took root, not because he raised his voice, but because he didn't have to. In the days that followed, the frenzy faded, but the echo remained. News outlets moved on to the next crisis, social media found new targets, and political commentators resumed their endless loop of takes. But inside classrooms, on legal blogs, and in quiet corners of academic journals, something curious happened. The moment between Senator John Kennedy and Justice Amy Coney Barrett didn't just survive the news cycle. It was studied. At Yale Law, a second-year professor opened his seminar on statutory interpretation with a clip from the hearing. He paused at Kennedy's invocation of Blackstone and turned to the room. "This," he said, "is what it looks like when someone turns structure into substance. Notice the pacing, the restraint, the pivot." At the University of Chicago, a visiting scholar included the exchange in her lecture slides next to canonical debates from the Warren Court era. And at LSU, Kennedy's old stomping ground, a first-year con law class applauded after watching the full 10-minute sequence unfold. Not because it was flashy, but because it was clear. Somewhere along the way, the term "the Kennedy moment" began showing up in academic writing, not as a punchline, but as a label. A shorthand for what happens when preparation meets principle, and when someone uses plain language to cut through institutional fog. The meme world ran with it, remixing the footage with everything from chess metaphors to slow-motion mic drops. But inside the legal community, the meme became a model. Journal articles began citing the hearing as a rare example of interbranch dialogue that wasn't performative. Think pieces asked whether we were entering a new era of legislative thoughtfulness. Professors noted how the exchange avoided the usual traps of ideological posturing and instead wrestled, genuinely, with the ambiguities of legal language. Kennedy, for his part, said very little. He turned down interview requests from cable hosts and refused to write an op-ed for national syndication. When a Capitol Hill reporter finally cornered him outside his office with a question about becoming a folk hero among law professors, he chuckled, adjusted his tie, and said, "I don't play to win arguments. I just try to ask questions worth answering." He didn't mention the thousands of messages his office had received from law students and attorneys. He didn't reference the editorials praising his restraint or the letters from constituents thanking him for reminding them that substance still mattered. He didn't talk about the rare note he reportedly received, unconfirmed but widely whispered, from a sitting federal judge that simply read, "Well played." What Kennedy did do was return to work, quietly, deliberately, without the need to spike the football, and that, more than anything, may have been why the moment lasted. Because in a city obsessed with sound bites, Kennedy had created something different, a case study. Not in arrogance or theatrics, but in control, in knowing the record, in knowing your opponent, and in knowing when to speak and when to let silence carry the weight. Months later, during a legal symposium on legislative drafting, a keynote speaker closed her address with a subtle nod. "We can spend all day debating the merits of Chevron deference or the risks of statutory ambiguity," she said, "but at the end of the day, the public doesn't remember our journals. They remember clarity, they remember fairness. And increasingly, they remember the Kennedy moment." Even Barrett, in a later panel discussion on constitutional interpretation, was asked about the hearing. She smiled tightly and said, "The senator made a compelling argument. It's a reminder that good faith questions deserve good faith answers." It wasn't quite a concession, but it was something. The story of that day never became a scandal. It didn't spawn subpoenas or outrage. No one walked out red-faced or issued a public apology. What it became was something rarer, a marker, a quiet benchmark of what civil disagreement could still look like. And in that, John Kennedy left behind something more enduring than a headline. He left behind an example.